What is it?
Iced tea. Iced tea. My levels were going down, so I had to take caffeine.
But today I had to hold my hand. Maybe I was just broke.
Mwenda,
Habari yako? Keti. Thank you. Thank you.
Your Honor, I appear with again my able friend, Mr. Johnson.
Just a moment.
My old friend, Miss Mwai. My old friend, Mr. Joshua Comboy. He must be from Mwai.
I am present here.
And my old friend, Miss Nekesi.
I'm present.
Thank you. Yes.
Miss Nicholas Ovinya. Mr. Mora Kabata. Mr. Noel Odiwol, present Your Honor. Mr. Otieno Robert, present Your Honor.
Okay. Thank you. Mute everyone online. Mwenda Njagi faces a total of 6 counts. He pleaded not guilty to each of the 6 counts. Plea was taken yesterday at 3 p.m. at the request of learned counsel for the accused person, namely Dr. Amino, who requested that plea be taken at that time, and he had another matter before Thika Law Courts, and there was slight delay in registration of the charge sheet from the prosecution side. Immediately after plea taking, the defense counsel for the accused person raised a number of objections, which they preferred to submit on ahead of submissions on bail bond pending trial. This ruling, therefore, relates to objections raised by the defense counsel on record. Mr. Brian, you may have a seat.
Thank you.
The first objection was with regard to participation of the Law Society of Kenya in this case as a victim. Mr. Omari, advocate for the accused person, submitted that the chairman of the Law Society of Kenya and members of the Council of the Law Society of Kenya cannot participate in this case because they are potential witnesses for the reason that they made complaint with the police and recorded statements that they can only appoint an advocate to represent the Law Society of Kenya as a victim, that the premises of the Law Society of Kenya, that is the headquarters, is a scene of crime, and that if investigations implicate staff or council members, then they might end up being accused persons, and for that reason is submitted, council members cannot appear in their official position. Relying on Rule 9 of the Advocates' Practice Rules, Ms. Mwai, also defense counsel, submitted that the same provides that no advocate may appear as such before any court or tribunal in any matter in which he has reason to believe that he may be required as a witness to give evidence before this court. Counsel relied on authority EKLR. she submitted that in those two cases, the advocates concerned were barred from participating in the trial as representing accused persons because they were potential witnesses. She further submitted that it is in the public domain that the Law Society of Kenya, through their chairman, lodged a complaint in this matter, and all members received a statement of the President of the Law Society of Kenya dated 13th of October 2023 that there was a resolution to report the issue of the accused person to the Directorate of Criminal Investigations. She submitted that the statement was signed by the President of the Law Society of Kenya, and therefore the President and Council members of the Law Society as a natural person who suffers injury, loss, or damage. He submitted that the court needs to make a determination whether the Law Society of Kenya is a natural person. He further submitted that some of the counsel representing the alleged victim, including the President of the... On his part, Dr. Haminu, advocate for the accused person, also submitted that there is a new concept in common law known as equality of arms, which means that an accused person being prosecuted should feel that there is equality in representation to be his witness, and that anything that he does in his capacity as a prosecution counsel is protected by Section 15 of the Office of the Director of Public Prosecutions Act, and that as long as he does his work in good faith, he is immune from civil or criminal claims. He further submitted that the said provision protects him from being a potential witness, and that there is no basis for barring him from the case, and that the choice of witness is within the mandate of the Office of the Director of Public Prosecutions, whom they will ably represent. Mr. Njue, on his part, submitted further to the submissions made by Mr. Owiti Let me read that again. Mr. Njue, on his part, submitted that further to the submissions made by Mr. Owiti, the submission by Mr. Wamboi that Mr. Owiti is likely to its membership, that no conflict of interest has been alluded to, that Brian Mwenda Ntwiga is an offended person and reserves the right to choose his advocate, and that by extension, his membership as a natural person touches on the Law Society of Kenya as a witness for the prosecution. On his part, Mr. Theuri, advocate, submitted that the complainant in this matter is a statutory body known as Law Society of Kenya, that the Law Society of Kenya is a statutorily incorporated body by virtue of provisions of the Law Society of Kenya Act and has absolute right to determine who will represent it in any proceedings before the court. That is of the Secretariat, and therefore administrative running of the society is a function that is exclusively of the Secretariat, that the Law Society of Kenya Council, established under Section 17 of the Act, only gives general policy guideline information he may have obtained from that client, or that he has obtained information from a client that is relevant to the issue before the court, and therefore rendering the advocate a potential witness. He further submitted that if they go by the qualification that has been given by the defense counsel, then any advocate is a potential witness, including the defense counsel, because the test given by the defense counsel is of a roaming target that can land on any counsel. But how the court balances the Article 50, Sub-Article 9 rights on participation of victims in this case. That Article 50, Sub-Article 9 of the Constitution expanded participation of victims in a trial with access to justice, and that what the Law Society of Kenya has complained about, if left unchecked, then the provision of justice will be severely compromised. He further submitted that the mandate of the LSK at Section 4 of the Law Society of Kenya Act is to protect the conditions of practice of law in this country, and that it is important that the statutory body charged with the responsibility of ensuring practice of law is not watered down and held in high ethical standards to have a say in these proceedings. Mr. Theuri referred to the case of Republic versus David Mushiri Mwangi, 2018 EKLR, where he submitted the question of participation by victim during bond stage was made, and court relied on the case of Joseph Waswa versus Republic, 2020 EKLR, and the case of Republic versus Frederick Oleleiman, where the court found that the Law Society of Kenya was a victim and was allowed to participate in Mr. Theuri, and further submitted that the Law Society of Kenya to the case of Nairobi City Council versus Thabiti, 1996, from the floor, and allow the LSK to participate in the proceedings. Further, that the President of the Law Society of Kenya introduced several advocates, and no evidence of conflict of interest has been presented before the court to demonstrate any conflict of interest, that there is no evidence that the prosecution recorded any statement from any of the advocates, nor indication that they will call any of those witnesses. He urged the court to allow the LSK to participate as per Section 4 of the Law Society of Kenya Act. Ms. Nicholas, on her part, while referring to the provisions that victims' right to participation in the process subsists throughout the trial, including during plea taking, actively and not passively, that the right to fair trial is enjoyed by victims and not just accused persons, is the right pronunciation. That's a summary of the submissions made by counsel for the accused person, for the prosecution, and for the counsel who have come on record for the alleged victim of the alleged offenses. Due to constraint of time, I could not have reproduced all the submissions in this ruling, hence the summary. I have considered all the submissions made by each and every counsel who made his or her submissions. The first issue for determination is whether what the defense counsel have raised fall within the non-description of preliminary objection. A preliminary objection must be on a point of law. It cannot be premised on any fact or allegation requiring proof. The Court of Appeal in the case of Mukisa Biscuits Manufacturers Company Limited versus West End Distributors Limited reported in 1969 volume of East Africa Law Reports at page 696. At page 700, paragraphs D to F, Law JA, as he then was, had this to say, and I quote, "A preliminary objection consists of a point of law which has been pleaded, or which arises by clear implication out of pleadings, and which, if argued as a preliminary point, may dispose of the suit. Examples are an objection to the jurisdiction of the court, or a plea of limitation, or a submission that the parties are bound by a contract giving rise to the suit to refer the dispute to arbitration." End of the objection is in the nature of what used to be a demurrer. It raises a pure point of law, which is usually on the assumption that all the facts pleaded by the other side are correct. It cannot be raised if any fact has to be ascertained, or if what is sought is the objection. It is important to note that as a good practice, it is proper that be filed and served a notice of preliminary objection stating the grounds upon which the same is to be raised, so that there is sufficient notice to the opposite party, chance to participate in the proceedings. Definition of a victim is found both at section 2 of the victims follows, I quote, "A victim means a primary victim or a family victim. Primary was a witness to the act of actual or threatened violence, the death or infliction of the physical bodily harm concerned, being a person who has suffered personal harm as a direct result of the offense," end of quote. A plain reading and holistic application of these provisions leaves no doubt that the Law Society of Kenya and one Brian Mwenda N. Sorry, there's a spelling error there. Let me correct it. A plain reading and holistic application of these provisions leaves no doubt that the Law Society of Kenya and one Brian Mwenda N., who are mentioned in the particulars of offense to counts numbers 6 and 1 respectively, are entity and person respectively, against whom the alleged offenses in the said particulars are alleged to have been committed. Each of those two is therefore a primary victim within the definition of victim at section 329A of the Criminal Procedure Code reproduced herein above. But still, even going by the definition at section 2 of the Victim Protection Act, there is no doubt that the Law Society of Kenya is an association of natural persons, part of whose membership includes each and every advocate appearing in this case, each of whom acknowledged that fact. From the definition at section 329(a) of the Criminal Procedure Code, the fact that one is a witness or a prospective witness does not preclude the person or the entity from being a victim. I find the decision, let me correct it before I continue. Yes. I find the decision of the Honorable Lady Justice Kasango J. in the case of Kraft Silicon Limited versus Republic, Criminal Revision number E30 of 2021, reported in 2022 KEHC 424, quite relevant to the circumstances of this case. In that case, the Honorable Judge said as follows, it's a long quotation, for a corporation, even where it is a corporation, is a shareholder of that other corporation, there is always a natural person who is a shareholder somewhere down the line, and it is that one who suffers the consequences of a crime committed against the corporation. Further, it is important to note that Article 50, Sub-Article 9 of the Constitution mandates Parliament to enact legislation to provide for protection of rights and welfare of victims of offenses. Shareholders who suffer from consequences of economic crime and who are not excluded under Article 50, Sub-Article 9 of the Constitution, differently from other persons, such as a family member of a person who has Kimuri Housing Company Limited and another versus the DPP, and Kenneth Njiru Njagi versus Republic, Lineal Company Limited and another, I find and hold that the corporation, just because they are in the shadow of that corporation. End of quotes. That authority is clear that a victim cannot just be a natural person alone. This authority is binding on this court. I therefore find and hold that the objection raised on the basis that the Law Society of Kenya is not a victim on the basis of the foregoing reasons. The next issue for determination is whether the President, the Vice President, and Council members of the Law Society of Kenya should participate in these proceedings, and whether the Law Society of Kenya should be asked to appoint an advocate to represent it, and not the President, the Vice President, or Council members thereof. It is the parties sorry, officer, fungua mlango tupate hewa. An advocate appears before the court and as an officer of the court introduces himself or herself as representing a party to the proceedings before it, the court has the right to be represented by advocate of own choice, not appear for a particular party. Such an application must be supported by evidence because the consequences, if successful, are major. Such evidence must clearly indicate a conflict which might arise as such advocate performs his or her dual responsibility in the society of Kenya, nor with regard to the advocates appearing for the Director of Public Prosecutions. Fair trial includes the right to legal representation of any person appearing before the court as a party. I rely on the publication by the United Nations Office on Drugs and Crime, otherwise known as UNODC, titled Rules and Guidelines on the Right to a Fair Trial and Legal Assistance in Africa, that efficient procedures and mechanisms for effective and equal access to lawyers are provided for all persons within their territory and subject to their jurisdiction without distinction of any kind, such as discrimination based on race, color, ethnic origin, sex, gender, language, religion, political or other opinion, national or social origin, property, disability, birth, economic or other status, unquote. And it continues to say, I quote, similarly, and the right to be represented by an advocate of own choice are key components of the principle of equality of arms. It is my view that by making a decision disqualifying an advocate from appearing in the matter without proper justification or basis would be tantamount to denying the party the right to be represented by advocate of own choice. There cannot be fair trial as contemplated under Article 50 of the Constitution without equality of arms. Based on the foregoing reasons, I find that the objection raised by the defense is merited. The objections raised are therefore each rejected and each of the prayers sought is declined. I am, however, grateful to each and every counsel for input and contribution to continuous learning of the law. That is the end.
For the High Court of the land. In John Kahindi Kalisa. John Kahindi Kalisa and two others. The decision is reported and add the court to just on page 4 of the decision. Must not have an affidavit in its attempt to prove the existence of a compelling reason for the denial of bail. That is my paraphrasing of that paragraph. I am confident that the Honorable Court will have an opportunity to have a look at it. And then that answers
Affidavit sworn by the law.
I'm informed that copies will be given.
What I have is sworn by Florence Muturi. Is that the one?
Yes, it's the one.
Oh, okay.
The deponent is Florence Muturi, on 18th of October 2023. We are persuaded on behalf of the state that indeed is an affidavit that can be relied on and should be relied on in objection to grant of bail to the accused person. We'll address you absence of an affidavit on the existence of compelling reasons to persuade this honorable court to find that bail should not and cannot be granted in the circumstances of interest. It does not conflict the right to presumption of innocence under Article 50, Sub-Article 2. So that a court that denies bail on the seriousness of the offense...
Just a moment.
Sorry. Does not in effect violate the presumption of innocence. Off my head, I could refer the court to the case of Republic versus Oleleliman, which has been referred to on the balance between the grant of bail and the presumption of innocence. I trust that the court would still rely on the copies that were served. Your Honor, if we persuade you that therefore public interest is connected and linked to the seriousness of the offense, and because the list of compelling reasons has been found not to be exhaustive, in addition to the grounds that my colleagues from the ODPP and the Law Society of Kenya will submit before you, we urge you to find that the integrity and or sanctity of legal practice, integrity and sanctity of legal practice in the country has a humongous bearing, and with anarchy, the business environment will collapse. That is how we affect both national security and national development. The importance of the integrity and or sanctity of the legal practice can comparatively be looked at in the international spectrum, where a failure of the peaceable, or what other people call pacific settlement of disputes.
Just a moment.
Sorry,
that will have a huge impact on the society. Before a decision to charge is made. I will not belabor on that because my colleagues spoke about it. Yes? And the case before court. You know, before a decision to charge is made, the evidence in the matter is considered, and the strength of the evidence that is reachable before court is considered. And again, Your Honor, I will take you back to the charge sheet. Before court is enormous, and the evidence before court will be compared. Point would be the antecedents and the character of the accused. Which I agree do not by themselves form the basis of denial of bail. But the same would be very important. When tabled for this court to consider. And that can only be done on a pre-failed report. Since the pre-failed report goes into the nitty-gritties of the character of the accused, and it will help this court to make a determination it is very clear that the accused has been practicing his attribute. And hence, he must have represented clients. Who are just right there and waiting for him. Any interest in it? I think the hearing and determination of this matter. For his own safety. With the reasons to table the property now. And in the interest of time, let me wait with you.
The two counsel for the script.
There are
I'm a little surprised.
three more minutes are remaining.
You know, I think my submission is the most brief submissions I have ever read since I started practicing. You know, I like to. And again confirm that I've had a chance of perusing the affidavit form by Florence K. Mutuli on behalf of the victim. You know, as much as there was opposition as to whether it's a proper affidavit or was made, I recognize that the court has not rendered it itself on that aspect. And I've seen that the affidavit has raised weight issues. As much as I know the Law Society will bank so much on it, I defy the court to be moved by paragraph 10 and 11 of the affidavit. To a question that is normally never answered when it comes to the issue of the board bill. Which standard should the state go for these materials? Your Honor, my appreciation is that the standards need not be to the standard duties of the government. As it is, as regards to prove accused person.
any response to it. That as my colleagues for the defense made, in a response they take into consideration the issues of the Victims Protection Act. Participating at the stage of court. We therefore wish to make our submissions. Your Honor, I will try as much as I can to talk about
Your Honor, read the politics. These are politicians looking for votes using this young man. Kindly protect this young man. Kindly protect this young man from future leaders of the Law Society of Kenya and JSC. That is the only reason we are raising it.
Full of malice.
You see now, Mr.
in opposition to the reason for. It's sworn by Florence Muturi and it's dated the 18th of October 2023. For him not to be released. As provided for in Article 49, 1H. Pursuant to a complaint that has been made to the police as against that person. That person presents himself to the police.
Your Honor, with respect, we are not going to be told things that are not true. He got from 1 o'clock to 11 o'clock. He walked into my office. I got in touch with Mr. Gret, and I told him that, look, I want to come to your office. Mr. Gret told me, I'm going to make an appointment. And I told him that I have got this young man. And he gave me an appointment from 1 o'clock to 11 o'clock, when he was given cash bail of 100,000 shillings. He knew he was being sought for, and he came to a prominent lawyer like Hamino. Hamino, can you do something for me? I said, yes. Let us go to the CID quarters. That's precisely what we did. What is it that we were saying that the young man was now trying to keep away from the case? Case of Mugunya, a police officer who had shot someone there, and he was charged with murder. And this was immediately the 2010 Constitution came into operation. I appeared before Justice Muhammad, who is now a Supreme Court judge. I argued the matter, told the judge, release this Mugunya, a senior police officer. He gave me an order, and I got him out. I have cited this case before your Honor, when you are magistrate at the Kenyatta Airport.
That whenever a person is aware that is being sought by the police, he presents himself before the authorities at the earliest opportunity. as it considers the question of whether to release or not to release, or what kind of conditions to impose, it is necessary to examine the conduct. We wish to play to the court a video, and we have produced the certificate of electoral televisions. And that video, Your Honor, will illustrate to this court the character to assist us playing the video that was posted on the 14th of September 2023 for him to attend university out of the country. For that reason, we submit that if the accused is released on bond, and given that there are already plans to admit him to a university out of the country, it is a possible flight risk. And Your Honor, that is a very critical consideration. Principal objective of placing an accused person on bond is to ensure that they will attend the 14th of October. And I think in their own words, whenever it's convenient. The accused is a hero. Secondly, Your Honor, he confirms that he has several lawyers and well aware that the police are seeking. The knowledge is very is that Mr. Brian Mwenda, the accused, makes a reference to a promise that he gave on Friday . Of October, that he would present himself on Monday. That is a law-abiding citizen who loves the law, and Your Honor, it is our submission that if indeed he was a law-abiding citizen, he would have presented himself as he eventually did on the 17th of October, accompanied by his advocate. He would have done so on the 13th. However, he was unable to do so on the 13th. He did not do so on the 14th. He did not do so on the 15th, and neither did he present himself on the 16th, as promised.
Not candid. If my president wants to be a DCI, let him go for training. Kindly let us hear averments about the accused not reporting before I'll escape.
Has at all material times to these proceedings taken the form of untouchability and invisibility. It appears that he may be apprehensive of the outcome of the proceedings. There is a likelihood that he will abscond trial. And in light of the same, it's our humble submission that this honorable court should not grant bail. I think I've spent 2 minutes.
Back on him for commenting on social media.
Just a moment.
Social media because Your Honor is causing further damage to the legal profession. In an irreparable manner. Your Honor, and this gag
Advice. I take a preacher's view. Take what you expect to be done. My 6 points are that. That tells you a lot. The DCI only constitutional body. No affidavit at the DCI to show the accused never appeared. Actually, the Law Society of Kenya, its membership completely feels ashamed of the council. Number 2, Your Honor. You have been told presenting the accused as an advocate. Your Honor, when you look at social media,
Sorry. Pardon? Former governor and others?
they have told your public interest that the accused is showing himself to the public and is touting them as an advocate.
I know we were to have a meeting, so all my colleagues have gone. I'm the only one remaining here.
You understand?
It's okay. It's okay. This one I can't read. I can't read this one.
Sorry, Your Honor, to interject. I don't know.
To produce documents as experts, they'll be marked.
Your Honor, will object to the marking as well, because first of all, before they even mark,
Cancel through their social media platforms. who have introduced this accused person as an advocate. They have recruited him.
Your Honor, may I?
As I finish my submission, I know it's going to be so lethal, but it will not stop.
And friend of the Law Society, I don't like my life. It's no longer with us. And we adjourn the matter and you give us another date. I have finished. Again, I appeal to you that to release a young man. It's not a threat to the court, Your Honor. Or else, when I also come to talk, things could go bad. Thank you.
Okay. Okay.
When we have mentioned the signature of the court.
Circumstances will be asked, Dr. As I indicated at the beginning, my intention was to hear everyone today and then you're going to end up for the day. But now I have not, I cannot force you to finish. And also time is not on our side, but it is at 5 p.m. Next week is my diary is very busy. How long will you take to finish?
What did you want?
Let's talk of Monday.
Go on.
On Monday, 9 a.m. And will you take more than 1 hour? Will you take more than 1 hour?
1 hour would be sufficient, Your Honor. 23rd.
So that by 10:15.
Your Honor, we have got virtual hearings. Can you give us about 11 o'clock?
From 11.
What time?
We are talking of 2, not 12. 2 p.m.
2 p.m. This one.
Okay.
Your Honor, I'm not willing.
It is now past 5 p.m. The counsel for the accused has indicated that he needs time to finish his submissions on another date. So the defense counsel to conclude their submissions on 23rd of October 2023 at 2 p.m. Since it is not appropriate to make an order for release of the accused person as sought by the defense counsel before determining the issue of whether or not to grant bail, the accused will be remanded in custody. So that marks the end of the session. Thank you so much.
that the council presented you with another. So we can just have another saying we not all they were presenting you as a council. So we can have another